Before you get started, did you get my notice or motion from yesterday?
I don't know.
Okay, I made a mistake. I made a mistake when I put in the original.
Is this the one you're talking about?
No, there was one I put in yesterday afternoon.
In this case?
Yeah. Well, there's two cases that original one addressed.
Hang
And
on, let me see. This is something else. It may not have found its way out here yet. Hang on a second.
it's all right.
What does it say?
Essentially, that I made a mistake with the implication. That I was under the impression that, let's see, case number 021.
Do you have your copy of the file?
Yes. Not in number 02189. In
Ones here that are NCR 1988. That's the case.
those are Class A's. Those I want to do the de novo with.
Okay. And this here. That's something to do.
Yeah, there's actually...
These were changed to Class A. Oh, one's a Class B.
I thought they were all Class B.
No, the contempt was originally filed as a class.
Sort of as a class, at least is what I'm looking at. I don't know what the prosecution can modify this with notice to you, but as it stands now, disorderly is a Class B. There's one disorderly that's a Class B, and one disorderly is a Class A. And
Well, that's the other thing I wanted to address was my...
And one is the Class A for common law contempt. That's what I'm looking at now.
Right. There's one of the disorders I filed a replacement complaint, that's Class B, that's Class A. I was just cleaning up the language of the body, and apparently the
Okay, so we are dealing with Class A.
A's
yeah.
across the board. So
Okay.
Well, with that in mind, I do want to go ahead.
Okay. And you understand what that means is that the prosecution is required to make an offer of proof. They have to indicate to me what they think the evidence would be.
Okay. Before you do that, the disorderly conduct, you mentioned it was a replacement. I see two disorderly conducts on this list.
Let's clear it up right now. So I've got one that Attorney McLaughlin filed dated October 12th. That's the one that's operative.
it is. It should be a Class
I just want to make sure that we're only dealing with one, not
And this
two.
other one's going to be null pros.
A. That's correct.
Okay, this one here.
Is that for me? Or?
That's for him to do.
And there's the same issue with the other case number 1988, where there are two obstructing government administrations. One was a replacement, and the other was never removed.
How many should there be here? Just the ones that you filed?
The obstructing government administration that I filed is active,
Okay.
and then there's a resisting arrest that was filed by Officer Sergeant that's active.
Okay, and the other two are null pros?
The other two will be null pros. One's
Okay.
a lesser included offense.
All right, so these are the only two we're going forward.
So they're null processing, disorderly, and one of the obstructings on that?
Yes.
Yes, the obstructing that was originally filed.
The one, yeah, the obstructing has Mr. Attorney McLaughlin's name at the bottom.
Yep.
That's the one that's out
Okay,
there.
just want to make sure we're straight on that.
Well, it's easy to get these things mixed up in one court.
Yep.
But going back to what we started to say before, you're entitled to counsel. You know, you could have applied for counsel if you wanted to. If you qualified financially, one would have been appointed for you. If you wanted to hire an attorney, you could have done that. But you've elected not to do it. That's right. And you've had enough opportunity to think that over?
Sure.
Before we go forward today? All right. All right, the state will have to make an offer of proof. And what you'll be entitled to is a jury trial in this case in Superior Court. You'll have to make sure they are aware of, keep them advised of your address if it changes or anything like that, because if they send notices out and you don't get them.
And you guys are going to send the paperwork over
We'll do
there,
that, right. But you make sure you check over there to keep on top of things. It wouldn't be unusual.
Will they be sending me a notice of a hearing date? Is that what
They should be, and the same opportunity to have counsel over there will apply if you change your mind again. They'll give you that chance again to do that if that's what you want to do. Okay? I have no idea what the scheduling is like over there for when you would hear about that. So.
Yeah, it's hard to say.
Okay, what's the state's offer of proof?
With regard to the obstructing government administration or resisting arrest charges of July 18th, on July 18th of this year, approximately 6:45 p.m., the defendant was with a large group of people in Central Square in Keene.
Sure, that's yours.
The police were dispatched to Central Square for reporting people consuming alcohol in public. Within minutes after the police arrived at Central Square, Heike Corser was taken into custody for an open container violation. He was placed in Officer Zamora's cruiser, and thereafter a number of people, including the defendant, surrounded the cruiser, preventing it from leaving. In addition, the defendant was heard repeatedly encouraging the action of surrounding the cruiser, and was also observed opening the rear door of the cruiser holding this Corser. Eventually, 2 additional people were taken into custody for obstructing government administration by blocking the cruiser's departure from the scene at Central Square. One of these people, Wesley Gilbert, was placed in the cruiser of Keene Police Officer Sergeant, which was parked in a rotary next to Central Square. As Officer Sergeant started to leave with Mr. Gilbert, the defendant stepped in front of Sergeant's cruiser, in front of Officer Sergeant's cruiser, and sat on the hood. Officer Sergeant sounded his siren, and the defendant refused to move. Officer Sergeant, who was in his police uniform and driving a fully marked cruiser, exited his cruiser and started to arrest the defendant. As he was doing so, the defendant started to go limp and fall to the ground. Officer Sergeant then lifted the defendant up and placed him in a police cruiser. In blocking Officer Sergeant's cruiser, the defendant obstructed vehicular traffic on a public street. With regard to the disorderly conduct and the contempt charges, on August 5th of this year at approximately 7 p.m., the defendant was in attendance at a Keene City Council meeting. The defendant and 3 other individuals were possessing and drinking from brown bottles that appeared to be beer bottles. As the meeting progressed, the defendant and the 3 other individuals would periodically raise the bottles in a toast-like fashion and drink from them. As this went on, it came to the attention of Mayor Pregent, who was in charge of running the City Council meeting. The mayor then made an announcement that possession of alcohol or containers containing alcohol or appearing to contain alcohol were not allowed in the City Council meeting. The mayor then stated that the containers had to be disposed of, or the persons had to leave. The defendant refused to dispose of his bottle or leave. The mayor then repeated his statements that the bottles needed to be disposed of, or anybody possessing them had to leave. The defendant again refused to dispose of his bottle or leave. The mayor then called a recess of the City Council meeting to allow Officer Nugent and Chief Miola of the Keene Police Department an opportunity to intervene. Chief Miola approached the defendant, and after the defendant refused to allow Chief Miola to inspect the contents of his bottle and refused to leave, he was arrested for disorderly conduct. At the time of his arrest on August 5th, the defendant was out on bail pursuant to this court's order of July 19th. That bail order contained a condition that the defendant was to be in good behavior.
Can I motion to have those charges dismissed here? Is that something we can do at this point?
Well, no, the reason for the hearing is because you're going to waiving trial and appealing for your, you can, the de novo trial means it's all brand new. It's as if you had your trial here and lost. And
so I can put in a motion to dismiss over
all
there.
those things can be done over there. It's like you have a clean slate. In fact, before we go, I want to remind you that the issue with respect to how you would like to be addressed, you have to raise that over there all over again. Okay.
Not a problem.
Okay. Well, I just want to just remind you that if that's what you want, you're going to have to initiate the process. All right. The state has a recommendation for dispositions on these cases.
Yes, Your Honor. With regard to the obstructing government administration, 360 days in the House of Corrections with all but 60 days suspended for 2 years upon the condition of good behavior, a $500 fine plus a penalty assessment. Resisting arrest, 180 days in the House of Corrections, it's all suspended for 2 years upon the condition of good behavior, consecutive to the obstructing sentence. Disorderly conduct, 180 days in the House of Corrections, all suspended for 2 years upon the condition of good behavior, consecutive to the obstructing sentence, but concurrent to the resisting arrest sentence. And then contempt, 60 days to serve, concurrent with the obstructing government administration sentence.
The court finds that the offer of proof to establish these cases beyond a reasonable doubt, based on the prior experience. The court finds the dispositions recommended by the state to be reasonable under the circumstances. I'm going to make those orders. Right, so the sentences will be on the obstructing charge, Were you held at any time in the jail on the first
Which
charges,
matter?
the ones from Central Square?
Yes.
Were you held overnight, for example? That's what I'm getting at.
Yes. That one, I think I was held overnight on that one.
And look, I don't recall. I thought he was processed and released, but...
That was in the drinking case.
okay.
All right, well, 1 day of pretrial credit goes on to that.
No, actually, right. It says here that
I seem to recall that,
he wasn't,
but I'm
that's
not
right, he
sure.
was not compliant with the bail commissioner, so he's held overnight.
All right, so on that charge, it's a $500 fine plus the penalty assessment, 360 days in the House of Corrections, 300 days are suspended for 2 years on your good behavior. Anytime I mention good behavior, that's usually defined as no felonies, misdemeanors, or major motor vehicle violations, plus any other specific conditions that might apply. The 60 days are to be served, and you get 1 day of pretrial credit. I'm noting in this instance, in all your cases, you're appealed to the Superior Court for a jury trial, so not all these sentences are stayed until you exhaust your appeal over there, or if you go beyond that point. On the resisting charge, it's 180 days suspended on your good behavior. That's consecutive to 367322C, which is the first one I read to you. In other words, if all these sentences were imposed, you have 300 days left over on this one, and there'd be 180 days that would be consecutive to that if you actually had to serve that time. You follow? Understand what I mean?
I follow you.
Okay. On the disorderly conduct charge, that's the same as the most recent charge. That's 180 days suspended on your good behavior. Concurrent with the resisting charge. Or consecutive to the obstructing charge. And then finally on the contempt charge, 60 days to serve. And again, that's concurrent with the obstructing charge. Okay, I've noted your appeals on all these matters. Does he need to check at the window before he leaves on that? Or is that still have your what's the appeal box sheet?
63 Emerald Street.
I think we have to
We'll
discuss
get more
that.
information on the timing over there and that kind of stuff, so you may just want to check it out in the hallway.
Check on what regarding?
Whether they have any idea about timings, or when you'll get a hearing over there or something, they may not know.
they probably
I don't know what their schedule's like at all.
Yeah. They'll send me notice. So.
They should. If you don't hear, and I'd say it's not going to be in the next month. If you don't hear in the next month, I would stop in and see.
Will there be different case numbers over there?
Oh yeah, they do put an S in between instead of a CR.
Alrighty then.
Okay, that's what they do, right?
Yes, yeah. And just to clarify, the most recent bail order is still the operative bail order for these pending his arraignment and...
Yeah, the bail conditions remain in place. Okay, in other words, the bail does that's set by here will follow you over there. You won't get a new arraignment. I don't think you get a new arraignment.
I think they might bring people in and arraign them on that. I don't think they just...
Yeah, they might. I think they want to know whether you can have a lawyer, those kinds of things. So that they may want to have a hearing of some kind over there.
Alrighty.
Okay.
Bye now.
Thank you.
Thank you.